In this Blue Eagle case, the decision of the Supreme Court cited the case of Revedad versus NLRC, where the Supreme Court declared that the proof of actual financial losses incurred by the company is not a condition sine qua non for retrenchment, and retrenchment may be undertaken by the employer to prevent future losses. Meaning, the company does not have to prove actual financial losses are really being suffered already, no? If you're just about to suffer financial losses, or it is imminent and very clear, no, that you will be on the way to suffering financial losses, you may implement retrenchment. You do not have to wait to actually and really suffer already financial losses. That is the content of this conclusion or the rule established by the court. No? Proof of actual financial losses incurred by the company is not a condition sine qua non. It is not a condition precedent. You do not have to suffer financial losses before you can implement retrenchment. You may implement retrenchment if it is imminent, clear that you will be suffering financial losses if you will not implement retrenchment. So that is another way of saying it. In its ordinary connotation, the phrase "to prevent losses" means that retrenchment or termination of the services of some employees is authorized to be undertaken by the employer sometime before the anticipated losses are actually sustained or realized. It is not, in other words, the intention of the lawmaker, no, sa labor code, to compel the employer to stay his hand and keep all his employees until after losses shall have in fact materialized. So di mo pugso na employer nga, uy, ayaw lang sa paglihok diya, ayaw pag-remedyo, ayaw pagbuhat og solusyon, ayaw pag-implement og retrenchment kay wa pa man ka experience og lugi. Pagpalugi sa dayon mag-retrench. That is not the intention of the law. Okay? Because if such an intent were expressly written into the law may well be vulnerable to constitutional attack as unduly taking property from one man to be given to another. That is the constitutional right of every person, natural or juridical. No man may be deprived of his life, liberty, or property without due process of law. And if you will force the employees, either in law or by policy, to keep all his or her employees until she will experience losses, then later, as he or she is already experiencing losses, implement retrenchment. That is unfair to the employer, because it is as if you are giving the property of the employer to the employees. No? That is deprivation of property. And if that is placed under the law, that will be subject to an attack, no? To question its constitutionality. Whether it is because the state is already asking, or the state through its law, if it is put into law, that you can only retrench after experiencing financial losses. If that is placed into law, the state is in fact taking your property without due process of law, thereby subjecting that specific provision of law, if such is put into law, to a constitutional attack. No? Dili pod patas. No? Imong pa saferon og losses yun ang employer before mag-retrench, maskin klaro na kayo, clear and imminent, na kalugi-lugi na gyud siya. Imo pa yung huwaton yung malugi, di po maayo. No? So, that is not the intention of the law. So, such loss was actually substantial and actual. So, in this case, the Supreme Court said that the employer here, Blue Eagle Management Incorporated, was a newly established corporation during its first year of operation, and there is no showing that such loss would abate in the near future. Meaning, si company, si employer, bago pa, bata pa, nag-losses. Kailangan siya mag-retrench. Kaya nag-suffer good siya ng losses, actual and substantial. Yun sa nimo pagkabaw nga actual, nalugi man yun. And it's not only actual that you are suffering losses. The losses suffered are substantial. Why? If you will evaluate this case, sa Sugod, it mentioned about the capitalization of the company. It also mentioned that this is a newly formed establishment. So for this newly formed establishment, a newly formed company with minimal capitalization, the losses incurred in the millions, sa iyang sitwasyon, substantial na to, and it was actual. Namang losses, so it was actual. Minilyon, yung gamay raw capitalization sa company, it is substantial. It would have been different if ang losses nimo, masin ka losses ka kada buwan, losses nimo 2 pesos every month, then the company is a $1 billion company. There is actual loss, but the loss is not substantial. So the requisite would be absent, and there would be no valid reason for retrenchment. No? There might be, but basing on this part of the law, of the decision, there cannot be a valid actual, there cannot be a valid retrenchment, because although the company is suffering from actual losses, but the losses, if multi-billion dollar kaya 2 pesos kaya mo loss kada buwan, that might not be considered substantial. No? In this case, gamay ra kay capitalization ng company, bata pa jud kayo ang kumpanya, and the company is suffering from the losses amounting to figures of millions. No? Yung figures, minilyon. So, dako na. So, that's substantial. So, the employer, Blue Eagle, had to act swiftly and decisively to avert its loss, since its MOA with Ateneo for the conduct of its business at the sports complex was for a period of only a little over 3 years. Mobo ra ba iyang kumpanya, iyang kontrata sa Ateneo nga tag-iya sa sports complex, kaya negosyo sa to employer diri to manage sports complex man. 3 years ra. Nya 1 year na siya dapit tag-operate, gasigi siya lugi. Minilyon, unya gamay ra iyang capitalization, basi hindi na siya kabawi. Tulo ka tuig ra gud iyang kontrata sa Ateneo to manage the sports complex. So, sa ani nga sitwasyon, si employer must act swiftly and decisively. Di ka pwede magpadugay-dugay o retain sa imong daghan nga employees. Kailangan jud ka mo paspas, chop off the finger to save the arm. No? Retrench ka dayon. So the retrenchment of employees appears to be a practical course of action for the employer, Blue Eagle, to prevent more losses, considering that iyang mga cost, no, maglisod og cover sa salaries, no, daghan kay siya mga basis diri. So mo na gisulti sa Supreme Court, no, it was proper for Blue Eagle to implement retrenchment. Also, unsa pa ilang reason ingon si Supreme Court, si employer nakapakita og resignation letter ni employee, na respondent, no. There was a resignation letter written and signed in her own hand. So for the Supreme Court, it was credible evidence. For me, it would be also. Why? Because there is no evidence to prove that the respondent, the complainant, the employee, was forced to, or was coerced. No, there was no evidence showing that a gun and a knife was pointed towards her, that the gun would be used to shoot her, and the knife would be used to stab her if she will not write and sign a resignation letter. There is no such thing. And there is no other, in this decision, you will not find any other form of coercion or vitiation of consent real enough to make the execution of the resignation letter involuntary. So as far as I'm concerned, I share this opinion that the resignation letter was voluntary, even if it was coached by the employer's representative. The contents were dictated to the employee. So even so, I don't think that will automatically make the execution of the resignation letter, its preparation and execution, involuntary. So that is one thing. So both the labor arbiter and the Court of Appeals invoke the oft-repeated ruling of this court that resignation is inconsistent with the filing of the complaint for illegal dismissal. The point is, there would be no credible resignation, even if there is a resignation letter, if the employee would subsequently file a case for illegal dismissal. That is a ruling of the uh, repeated ruling of the Supreme Court in some other cases. That might be true in some instances, but the reality is right now on the ground, most of the times that is not true. Why? Because after you resign, sa Bisaya pa, na makasulsul ba? Uy, kailan nag-legal dismissal, makakwarta pa ka. Paano na yun? Pila na may pagsulti, gipugos ko. I did not execute that resignation letter. That is not my handwriting. That is not my signature. Or, okay, that's my handwriting. That's my signature. But I was forced. I was coerced. There was vitiation of consent. I was not voluntarily writing and signing that resignation letter. Malay mo, prasani mo. Si employee makadaog, usay mapildi. What if makadaog siya? Makakwarta siya. But kung pildi siya, wala, no? I'm not saying here that the complainant is in bad faith. But the reality on the ground, a lot abuse the process. So as an employer, no, you must protect yourself. Always be very particular with the nitty-gritty, like in the craft, execution, design, and the method of procuring resignation letter. Always exercise finesse, accuracy. No? Always have good design in order that the resignation letter later on, if put to test, its credibility and its probative value would be very good and reliable. No? So for the Supreme Court, there was no proof of such threat ever made with respect to, or there was no proof of threat, or it was a mere allegation. No? It might be true, but there was no evidence. It was a bare allegation. Mura siya ba pasangil nga gahukas, white t-shirt, walay ni suporta nga ebidensya. That is the reason why the court did not find that there was involuntary resignation. But if there was evidence, the decision might be different. No? So as far as the Supreme Court is concerned, the resignation was voluntary. There was no proof that the preparation and execution of the resignation letter was involuntary or against the will of the employee, that she was threatened, coerced to prepare the resignation letter and sign it. There was no proof. I'm paraphrasing, but that is the content because the decision is very long. So that is the point, no? So finally, to close, the Supreme Court said, even if said resignation letter also constituted a quitclaim, because this was pointed out by the labor arbiter, this is not a resignation letter, this is a quitclaim. So it could be that the employee who executed the resignation letter that appeared to be a quitclaim was in fact dismissed and later was asked to execute a quitclaim. So even if said resignation letter also constituted a quitclaim, what did the Supreme Court say? The employee cannot simply renege on the same. Hindi mo pwede bakwion lang. Because it is not uncommon. No? I've witnessed this several times. Papirmaho nimo, valid. Musugot, dawat tas bayad. So after 1 week, mo file of case for illegal dismissal. So ikaw magbantay yun ka. Kaya ikaw, employer, HR manager, or ikaw abogado, tukon kasi mo employee. Ay tukon kasi mo ang amo. Loy kayo yung employer if you will be very lenient pa in procuring a reliable resignation letter. Dapat detalyado yun. No? I mean, not the details in the contents because it would be too unrealistic, but as to how you procure it and to maintain, to gather evidence in proving later on that the resignation letter is very credible, was executed voluntarily. So that is your job, no? As an employer or HR manager, you have to make sure that your resignation letter that you procured from your employee who resigned will be credible. Ayaw kumpiyansa, no? So final note, what is the final note? The Supreme Court cited the case of Solid Bank Corporation. This is a very nice closing statement. That will be the topic of the next episode.